Hello, I'm Locke Meredith with Legal Lines. I'd like to invite you to join us on today's show with Burton LeBlanc. He is the president-elect of the Louisiana Trial Lawyers Association and also a national organization. Basically, what those organizations do is protect your rights at both the federal level in Congress and here in the State House in Louisiana. So join us on today's show with Burton LeBlanc. Welcome to Legal Lines. I'm Locke Meredith. I'm pleased to have on the show today Burton LeBlanc. Burton is the president-elect for the Louisiana Trial Lawyers Association. He's on the Board of Governors with the American Trial Lawyers Association. Burton, thanks for being on the show.
Thanks for having me, Locke.
Tell the folks a little bit about yourself, just kind of educational background so that they can kind of know where you're coming from.
Sure. Born and raised in Baton Rouge, lifelong resident. Practice law here in Baton Rouge and represent people all over the state of Louisiana.
Let's talk about how you got involved in, I guess, I don't want to call it the politics, but bottom line is that's what's going on in your involvement in the Louisiana Trial Lawyers Association.
Yeah, essentially, by virtue of my law practice, it's led me to the legislature. I represent individuals who've been exposed and harmed from asbestos and suffer from asbestos-related diseases. And the Louisiana legislature 3 years ago had a bill. They wanted to pass a law that would limit the rights of asbestos victims. And we've been fighting a similar issue in Washington for the last 6 years. So simply by virtue of representing the clients that I represent, it led me to not only the courtroom but also the legislature.
Which is something we really didn't learn in law school, is it?
Entirely. When I got out of law school, Locke, I figured, I'd study hard, learn how to read, and know the law, be able to communicate somewhat effectively, and I could represent my clients. And it turns out that the total practice of law, really for everyone, if you really take a step back and look what's going on and how laws are passed, if you really want to represent your client, you need to know what's going on in the legislature.
Let's talk about the organizations. The American Trial Lawyers Association is really a national group that does what?
Well, the Association of Trial Lawyers of America is based in Washington, D.C. They are a collection, it's a voluntary association, lawyers from all over the country, and they have people in Washington who monitor laws that are introduced in Washington. And essentially, they are a national organization and to see what's going on in Congress.
And to, I guess, put it in layman's terms, it's an organization that was developed basically because of the scenario you described on the state level, and that is the federal government was passing laws or considering passing laws that were going to affect the rights of victims,
yes,
people who are injured in some way, form, or fashion.
That's exactly right. I mean, it's a group of lawyers who represent individuals whose rights were being impacted by laws in Washington. These people, and they don't have the financial resources, the average citizen, a consumer of our state or other states, they can't go out and hire high-priced lobbyists on K Street in Washington. So what in essence happens by default, their attorneys on a volunteer basis stay in contact with people in Washington to make sure that their rights are protected.
And it's interesting because, the organizations, I guess, are defined by the other side as being, lawyers protecting lawyers, and that's really not what it is. If the lawyers didn't do what they're doing in these organizations, the folks they represent would be the ones that are suffering the consequences.
That's exactly right. In fact, I like to tell people I represent you, and in fact, I would suggest that I probably represent many of your viewers and their interests in the legislature. We speak on behalf of any consumer, the average citizens, those who do not have access to the political process. We are there to make sure that all individuals, whether they're the largest corporation or the smallest individual in the neighborhood, has the same equal access to justice.
And let's explain that to the folks, what it means. Because really what we're talking about is you got different interest groups that have different wants and desires. And so let's say a business organization goes up and says, we need you to pass these laws to protect us from losing money if we make a mistake. Mm-hmm. And our associations go up and say, wait a minute, we need to explain our position and why you don't want to do that. And really what it is, and it sounds like a bad word, but lobbying is nothing but educating the elected representatives on the federal government or in the state government on what the issues are and explain in a logical fashion why we take this position.
That is, in essence, you described the process. And the way
and you've done it.
I have done it, and it's not because I raised my hand and said this is what I want to do. Again, it's because my practice has put me in that particular arena, and if I didn't do it, and if I didn't go down there, then I would see the rights of the clients that I represent. They would have no rights, and it come to find out, there are many instances down there when the rights of our citizens are being dramatically affected by legislation, and often the citizens of our state aren't aware of it.
Don't even have a clue.
Have no clue, and it's not no fault of their own. They're hardworking people. These are just like you and I. We coach little leagues. We go to church on Sundays. We work hard during the week, and what goes on down in the legislature, that's a difficult thing to keep up with. However, the corporations, the CEOs, and the big companies have lobbyists there all the time.
Paid millions of dollars to do so.
And they're paid handsomely. And let me back up. I don't fault big business. Business is necessary. Business is the economic engine that drives this state. I'm for business. However, when companies are only concerned about profit margins and they hire lobbyists to pass laws that help
their criteria.
Sole criteria, help their profit margin, but at the same time hurt the rights of ordinary citizens, somebody needs to be there to speak up.
And it's a fairness issue. It's explaining to the folks that we've elected why that particular law or act is not worth passing. Yes, it may benefit that segment of society, but it's going to harm this segment of society, and they have to balance what's fair.
Correct. And I should mention, Locke, that most of the laws, either in Washington or on the state level, are being promoted by special interest groups, either the tobacco industry, it could be pharmaceutical industry, or other large corporations seeking to improve their profits. That's understandable. Rarely, if ever, do we actually go to the legislature and promote a law. We're there to protect what's always been here in this country, the constitutional right to a trial by jury, equal access to the courtroom, both for the largest corporations or the smallest individual.
And it's hard.
And it's very difficult.
Explain to the folks, I guess give them a day in the life of what you just experienced recently when you went up to D.C.
Well, in Washington, there was an asbestos bill pending that, in essence, is a bailout bill.
Is that what we've seen on TV? You know, Congress is considering this fund that's going to pay all these damage claims, and not a penny's coming from the federal government?
Yeah, and because you saw it on TV, you see the type of resources that these companies have. And documented lobbying fees, the asbestos industry and their friends paid $100 million to the lobbyists to get this bill passed. And so they had a financial incentive to get it passed. They would have saved $30 billion in estimated payments that are on the books right now and due to people suffering from cancer and other asbestos-related diseases.
We're not talking about bumps and bruises from a rear-end car wreck.
No, this is not.
We're talking about life and death.
In rear-end car wrecks, not to minimize them, but these are very serious cases. The asbestos companies knew that their products would cause harm to individuals dating back to the 1930s, and now instead of paying up where they owe, they're looking for Congress to give them a bailout. And my experience there, you asked, was amazing. We felt like the underdog all the time, but we did meet with senators. We brought clients up there, and it was an interesting process.
Well, let's talk about that in a little more detail in the next segment. This is Locke Meredith, Legal Lines, and Burton LeBlanc. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith. Again, pleased to have on the show Burton LeBlanc. Burton is the president-elect of the Louisiana Trial Lawyers Association and the national group that basically lobbies Congress also. Burton, you were going to give the folks kind of an example of a day in the life of what you do in D.C. Tell them.
Well, travel to Washington, set up...
And first of all, nobody's paying you to do this.
No, actually, this comes out of our own pocket. But we go up to Washington. The Association of Trial Lawyers of America will often set up interviews and meetings with senators or interest groups.
Which takes weeks.
Takes weeks. To put it in perspective, beginning in January of this year, I probably spent 6 weeks in Washington from January to March. But we'll meet with senators, we'll tell our story, we'll meet with press. We met with Senator Vitter, Senator Landrieu from our own state. Locke, we actually brought clients of ours to Washington. We felt that it's one thing having a lawyer articulate and tell our story, but it's entirely a different issue.
See a face,
when a face comes. And we brought individuals suffering from cancers that are only caused by exposure to asbestos. We brought them into Senate offices. We did press conferences with them, and it made a great impact, and we were successful at this point in beating back a terrible piece of legislation.
And that legislation was basically going to, as you say in the last segment, save billions of dollars for the company that it's already been determined they owe.
That's correct. Upwards to $30 billion savings. It takes every single case out of the court system. You as a lawyer would not be able to go to court and have a judge or jury decide your dispute. It takes cases, Locke, where you've already settled a case out of the court system. It takes that settlement, says no, you now have to go back to the end of the line and hopefully get processed under a newly established bureaucratic scheme that's not even tested. It's a terrible piece of legislation.
And this time the system worked.
And this time the system worked.
But if you guys and other folks like you hadn't been there to go educate the representatives, the legislators,
I can assure you this bill would have passed. The resources that we faced were insurmountable. Only because we had the better story and were able to get our clients engaged were we able to stop this law that would have affected millions of people.
And when you say better story, what you're really saying is that this is the truth. This is the consequence of this decision if you make it.
That's exactly right.
And a lot of folks owe you guys a great gratitude for what you've done. Let's shift down a little bit to the... Well, before we do that, tell me what the big issues are that we faced in the last couple of years on the federal level.
Well, on the federal level, we've had the asbestos bill's been there for 3 years, and we've beat it back every year. It looks like it may be dead now, thank goodness. We had a class action reform bill that they described last year, which was the president's first piece of legislation.
And it passed.
And it passed by a single vote also. So these are very hotly contested, close votes. That bill passed, and that takes every class action lawsuit and essentially federalizes it and puts all of the cases in the federal system, which is inconsistent with states' rights and some of the constitutional law that we've learned in law school. Mm-hmm. But that is what occurred.
And the reason the other side wanted that is why?
Well, essentially, they wanted to be able to control, in their opinion, had a better chance of winning these type of cases and put them in federal courts where the judges are appointed by the prevailing party in power. Which
and there's no accountability. They're not subject to election.
That's exactly right. That's exactly right.
And the jury pool is from a much larger segment.
That's exactly right.
Less localized.
Yes. So that bill passed. Locke, we've always had a medical malpractice bill kind of simmering in Washington, and it's never really passed, and it's still up there. As you know, in Louisiana, we already have caps on medical malpractice cases. Medical malpractice cases in Louisiana have been capped since 1975.
Right. And no adjustment at all.
There's been no inflationary adjustment, no economic adjustment. And what many consumers and even doctors don't realize that in face of caps, where there's limits on damages, and let me back up. You know, I have some of my best friends are doctors. I love doctors. They play a very important role in society. You're a great lawyer. We have lawyers that do the wrong thing sometimes.
That's why we have insurance, to spread the cost to a victim amongst thousands and hundreds of thousands of people instead of one person bearing the entire loss.
And some doctors may have a problem, a substance abuse problem, something that affects their practice and ultimately harms an individual. Well, these caps have been in place here for 30 years. The insurance rates for the doctors have risen up to 113%.
Which was the reason touted, keeping insurance premiums low for going for the caps. Let's cap it at $500,000 for all general damages. And, you know, insurance premiums you would think would stay low.
And so the question is, why have they risen 113% in Louisiana when we've had a cap for 30 years? So,
and what's the response? How do they answer that?
Yes, how do they answer that? But unfortunately, again, this is a perfect example of what we do. The lobbyists for the insurance industry have a lot of money. They have access. They get out and they tell their story. And they frame their story that good doctors are being run out of the state by these malpractice lawsuits. President Bush talks about jackpot justice. Well, there's no such thing as jackpot justice.
That's why we have appellate courts.
In Louisiana, every single appellate court can limit the damages and do limit the damages to a certain threshold figure. There's no such thing as jackpot justice. A lawyer who represents an injured victim has to study that case before he gets engaged. He's put his own resources on the line.
Because to litigate a medical malpractice claim costs thousands and thousands of dollars, because you have to hire experts to testify. It's a long, lengthy process. It's just not something you do lightly. Plus, you don't want to go after somebody if they didn't do something wrong.
They're complex cases, they're very challenging cases, they're very expensive cases, and at the end, your damages are capped. So the point being is medical malpractice is still an issue simmering in Washington, but it's being motivated, quite frankly, by the insurance industry. And that's another one that we're in touch with.
What do you see as the big issues that we face on the federal level in the next coming years?
I still think medical malpractice will be there. They've got their relief on class action reform. They may try to make another move with asbestos. I'm not sure if that's going to work out for them or not. One thing that's really interesting, Locke, that I don't even think a lot of lawyers are aware of, is that the federal government is now preempting. That means they are taking cases that belong in the state court system and removing them to federal court. Typically that was done by passing laws through the Congress. Now the executive branch, the president, is doing that through administrative orders, through the FDA, and through other departments, and that's something that we need to keep a watch for.
Now, how is that constitutional?
We don't think it is, but right now it's happening, and the constitutional challenge has not worked its way through the court system yet.
So basically, executive branch is not liking the way it's going in the court system, and at least on the state level, and just saying, well, we're going to take this and put it in the federal court.
And worse than that, you know, our Constitution says that laws such as that need to be passed by the House of Representatives and the Senate and then signed by the President. In this instance, the President, for example, in pharmaceutical drug cases, the FDA will promulgate, institute rules. And in their rules, they will say that all pharmaceutical cases belong in federal court. Well, that's a province of the Congress, not an executive branch function, but we're seeing more of this type of activism in the executive branch.
Let's talk on the next segment on the state level, what issues have been faced in the past and what we see has come up in the future. This is Locke Meredith with Legal Lines and Burton LeBlanc. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith. Have on the show Burton LeBlanc. He is the president-elect of the Louisiana Trial Lawyers Association. We are talking about the federalization by the executive branch of certain categories of cases or litigation, meaning that he's taking them out of the state and putting them in the federal courts. Give us an example.
An example would be the Vioxx cases that have received so much notoriety lately. A jury in Corpus Christi, Texas, found the Vioxx and Merck liable and at fault and awarded a damage award. That case, under these new rules, will be in the federal court system, which is a much more favorable place to be for a pharmaceutical company.
And what's so interesting is by the same part of the government, the federal government, that approved the use of Vioxx as a medication in the first place. It almost seems like a conflict. Interesting dilemma. Yes. Not to mention the fact that states are supposed to be the ones that have the rights, and we give the federal government the ability to exercise control, not vice versa. They don't just decide without involving the legislative process, meaning our representatives from the states.
Yeah, the party in power in Washington right now, while articulating that government should be smaller and the states' rights should be larger, in this instance is making the federal government larger and limiting the rights of the states.
It's interesting. I mean, it truly is interesting. Let's shift gears.
Yes.
Let's talk about the issues that face us on a state level. What are the issues that we've dealt with in the past few years? You had mentioned one, and then what looks like is coming down the pike.
Well, in the last 6 years, we've had a lot of legal reform, is the description the other side uses in Louisiana under the Foster administration.
Kind of taking away rights?
Yes. Under the Foster administration, the legislature was real active in this area. I think and sense that there's not much more that can be done as it relates to taking the rights
really over to that side right now
of the citizens of our state. And I would add that the devastating hurricanes that we experienced this past year in Louisiana, Katrina and Rita, I think have been an eye-opener for a lot of citizens who've never had to deal with insurance companies, have never had to think about hiring a lawyer. It just turned so many lives up and down that I just don't think that the legislature this year in 2006 is going to do anything controversial to limit the rights of consumers and citizens of the state. And if they do, we're going to be there to speak up.
It's interesting. We were talking before the show about this whole statutory employer law, and I know most folks don't have a clue what that means, but basically if you're injured while you're in the course and scope of your employment, your recovery, if the injury is caused by a co-employee or a defective piece of equipment that your employer owns, is limited to workers' comp.
Yes.
You don't get pain and suffering, mental, physical, anything like that, and your recovery is limited to percentage of your wages and your medical expenses, and that's it.
That's it.
Now, you don't have to prove fault,
Right.
so it doesn't matter whether the co-employee was negligent or not. If
Right.
you chop your own foot off, you get workers' comp. But what's happened is the legislature has extended that protection of an employer to folks who have absolutely no relationship with the person who's injured, the
Right.
employee.
Right.
They call them statutory employers, and
Yes.
it's been extended further and further.
Right.
And in essence, it's doing what?
Well, it totally it gives immunity to everybody upstream who would have responsibility for an injured client of yours. And I'll give you a good example. It's so egregious at times. You can represent someone comes to your office and he says, I was told by the person on my job site to stick my head in that gas well there and untwist a valve, and it blows up and explodes in his face, and he knows he never should have been in there. Well, the person on that job who told him to do that has no responsibility.
Immune from liability, other than workers' comp.
Totally immune, and in fact, the workers' comp carrier is probably his employer, which often might not be the person on that job site who told him to do this hazardous thing.
And they're protected.
Totally protected.
It's crazy. And what aggravates me so much is, again, the whole concept of insurance is to be able to spread the loss of a victim amongst hundreds of thousands and millions of people.
Yes.
Everybody pays a premium,
Right.
and that way the victim, the person who lost a leg or can't work anymore, is not bearing the whole brunt of the loss. And the system is getting skewed with this whole statutory employer bit.
It has. So we've seen no-fault insurance that you're familiar with. That's been a topic in the legislature.
Always comes up.
Always comes up. I don't think that has any chance. What we've seen in other states that have passed no-fault insurance, believe it or not, insurance rates have risen.
Shocker.
Yes. So a fault-based system actually works. What we've seen, Locke, most recently in the last several years is not legislation that impacts a large number of people in the state, but whenever there's like one or two cases that an industry just is not happy with, they will react and introduce legislation that will overrule one or two cases. And
I know another issue that comes up is always the level of damages necessary to get a bench trial or a jury trial.
yes,
Recently trying to change that.
right.
Discuss that.
I think that issue will definitely come up this year, particularly in light of the hurricanes, okay? Right now, if you plead that your damages are less than $50,000, you're entitled to go to court and allow a judge to hear your dispute.
Which often is much cheaper.
Quite cost effective. We don't have to go out and pull a jury from the community. It's a dispute that doesn't involve large dollars, and
The judge understands the law.
the
You
judge
can
understands
stipulate
the
a lot
law.
of
The
information.
judge can work your case in his schedule. He can hear testimony for an hour on Monday, and if he needs to come back and finish up on Tuesday or Wednesday, then justice can occur. The same process with a jury could take weeks.
Right.
And particularly in Hurricane Katrina and Rita, we think that the jury threshold needs to be raised, maybe up to $250,000 to hear the hurricane disputes. That way they can get in front of a judge quick, they can get their dispute heard.
And it's inexpensive, or less expensive.
And they can get justice much more efficiently and cost effectively. It doesn't place a burden on our public resources, on the clerks going out and finding jurors. Now think about this, Locke. If you're in Orleans Parish, St. Bernard, Plaquemines, or Calcasieu,
How are you going to get a jury?
How are you going to get a jury? Thus, I really think the legislature needs to study that issue, and if anything, sunset it. In other words, leave it out there for 3 years, and then
Take care of the
reevaluate it and bring it back. But that's an issue that's very important to all the citizens of Louisiana.
Tell the folks about asbestos litigation. I know that's what you specialize in, and explain how this has happened.
Asbestos is a product that's used almost universally in all the plants and shipyard settings, wherever there's a hot process. The companies who manufactured asbestos knew back in the 30s and 40s that their products would cause lung disease and cancer. Truly, this is the largest fraud ever committed on the American public. These companies conspired with each other to withhold this vital information from the medical community, the government, and the worker.
Sounds amazingly like the tobacco litigation, doesn't it?
Except I sense that it's worse. And between 1949 and 1979, 27 million people just in the construction trade were exposed to asbestos.
And the injuries we're talking about from it are serious.
Serious. Asbestos causes a type of cancer called mesothelioma, and the only known occupational cause of this cancer is exposure to asbestos.
And typically they die?
Within 12 months.
It's a sad situation.
It's sad, and I should add that in Louisiana there's been a disproportionate number of cases due to the volume of large petrochemical companies and industry that we have between Baton Rouge and New Orleans. So in Louisiana, it's really affected our citizens.
Burton, thank you so much for being on the show.
Pleasure.
Look forward to having you back on.
Thank you.
This is Locke Meredith with Legal Lines and Burton LeBlanc. Thank you for being with us.